Hello everyone, we are the BSPHED Group 7, the 4th presenter in Law on Obligation and Contracts, Chapter 4, Extinguishment of Obligations.
We're going to discuss the chapter for extinguishment of obligations. Under 1231, we have here the different modes of extinguishment of obligations. It starts by payment or performance and ends by novation. And also have here the other causes of extinguishment of obligations, annulment, fulfillment, and so on. Pero hindi na po natin siya, hindi na po siya covered dito sa chapter 4. Maybe sa mga susunod na chapters is mas may discuss po siya. Kaya focus lang po yung discussion natin sa 6 common modes of extinguishment of obligations. Next. Article 1232, payment means not only the delivery of money but also the performance in any other manner of an obligation. In ordinary parlance, payment refers only to the delivery of money. Well, ako rin nung una akala ko, pag payment, ibig sabihin, yung pambabayad mo lang is money, but it has a much wider meaning pala, no? So payment may consist of not only giving the money, or not only delivery of money, but also the giving of a thing other than the money. It is doing of an act or not doing of an act. Kasi diba ang obligation is necessity to do or necessity to give, to do, or not to do. And so kailangan natin tandaan under Article 1232 na ang payment is not only confined to the money but also to giving, doing, or not doing a certain act. And when we say payment or performance, kasi we refer to the fulfillment of obligation, hindi lang nagpo-focus to sa money. Next, payment or performance. Ang payment kasi, di ba, we all know payment kapag may utang ka, kailangan mong bayaran. And kapag naman tong utang mo na to is nabayaran mo na, ma-extinguish ng obligation mo, mawawalan ka na ng obligation. And then, yung mga payment or performance, were they different sa pagdating dito sa extinguishment of obligation? So, in law, payments or performance are synonymous. Meaning, yung performance of an act, it may also constitute as payment under 1232. So, eto, may mga hinati po tayong subtopics dito and ginawa na rin siyang questions para mas madali nating matandaan or ma-identify yung gusto ipahayag dito. So, number 1, who can pay? Sino pwedeng magbayad para ma-extinguish natin yung obligation natin? Obviously, ang alam lang natin is yung may utang, pero mamaya mai-discuss natin kung sino-sino ba yung mga pwede pang magbayad. Number 2, who to pay? Sino babayaran mo? As usual, ang isipin din natin dito is yung kung saan tayo ng utang, doon lang tayo pwede magbayad. Pero hindi lang po doon, later madi-discuss din po natin. Number 3, what to pay? May mga different rules tayo regarding payment or performance. Depende sa kung anong klaseng obligation or babayaran. Or may specific thing lang na babayaran. At yung specific thing, ito lang yung money. Kapag sinabing specific thing, it's all about money. Kapag sinabi namang generic thing, it is obligation to do or not to do. Ganon. Nakadepende yun sa specific thing or generic thing. Number 4, how to pay. Kailangan dito yung payment kompleto. May explain rin natin in detail. Number 5, where to pay. Depende sa pag-usapan ng mga parties. And may mga rules din dito kung anong mangyayari kapag wala sila na pag-usapan. Number 6, when to pay. Kung kailan ka na obliged bayaran or gawin yung isang bagay. And ayan. Next. Under Article 1236. This time, hindi po tayo magdi-discuss ng chronologically na article, ha. Ito po ay i-base natin sa mga subtopics na 1 to 6. Then, papahapyawan na lang po natin sila. Dahil related articles lang po sila. So, itong first, Article 1236, the creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation, unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge of against the will of the debtor, he can recover only in so far as the payment has been beneficial to the debtor. So, babasahin lang po natin, explain din po natin mamaya. Ayan. Ayan na po yung sinasabi ko kung who can pay. Kung yung nangutang lang ba yung mga pwedeng magbayad. Ayun, ayan, meron tayong tatlong pwedeng magbayad para mai natin na valid yung payment nila. Number one, first, debtor. Ayun na po yung yung nangutang. Number two, authorized agent kung merong mag-act as their behalf. Number three, successor in interest. Kunwari kapag yung nangutang is namatay na, then may mga anak and properties naman siya. As usual, yung mga anak niya, mamanahin yung properties niya. Ngayon, pati na rin yung utang ng tatay nila, mamanahin na rin nila yun. So, magpo-fall to parang magkakaroon ng chance na parang yung property ng tatay nila, yun na lang yung pambabayad nila. Yun, valid payment pa rin yun. Kasi property naman ng tatay nila yun. Next, pwede bang magbayad ang third person? Yes, because it is under the law. Pero may mga certain scenarios tayo dyan. Ayan yung mga interested, not interested, does not intend. Ayan, may mga certain rules tayo. I-illustrate po natin yan sa mga susunod na slides. Ito yung related article. Related article 1238, payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation which requires the debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. Ayan na po yung example natin sa interested. Ito naman yung para mas maintindihan nyo yung sinasabi ko kanina, may mga different scenarios yung third person. First one is the interested in the fulfillment of the obligation. Sino nga ba yung mga interested na yun? Guarantors, the sureties, preferred creditors, and the owners of the security. So ayan, sabi sa key points, there will be valid payment. Ayan, so meron tayo ditong example. After the example, ayan. Hindi niya pwedeng itong mga third person natin hindi pwedeng tanggihan ng creditor dahil nga valid, interested siya sa pag-fulfill ng obligation. Number 2, after bayaran ni may sinabi kasi dito na G presented payment of 1 million to C. After bayaran ni G is the third person. Yun siya yung interested to fulfill the obligation. Siya ang nagbayad ng 1 million kay C. Ayun, binayaran niya. After niya bayaran yun, si D naman magkakaroon siya ng obligation kay G. Kailangan niyang bayaran yung 1 million kay G dahil siya yung nagbayad muna or siya yung nagsilbing guarantors para mabayaran yung 1 million kay C. Nagkaroon na sila ng valid payment kasi nga siya interested in valid to interested in the fulfillment of obligation. C, guarantors. Ngayon, kung ilan yung binayad ni guarantors kay C, yun din yung kailangan bayaran ni D kay G. So ngayon, kung wala nang cash or wala nang pambayad si D, pwede nang i-foreclose pwede nang foreclose ni G yung pledge sa car ni D. So, pwede na yon. Magiging proceeds no foreclosure. Ayan, yan ang pwede niyang pambayad. Next. Another related article, 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter can compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, and penalty. Ayan. Ayan naman yung next scenario natin, not interested. Ayan. D is indebted, example, D is indebted to C for 1 million as security. D pledged his car 2 months before the debt matures. D paid 100,000 pesos to C, which the latter accepted. 1 month before the debt matures, X presented payment of 1 million to C. Ngayon may utang si D na 1 million kay C. Ngayon, nagpauna muna siya ng 100 pesos kay C. Tapos, eto namang si X, which is the not interested in the fulfillment of obligation. Nagbigay siya ng tandaan nga po pala dito sa not interested in the fulfillment is the creditor can refuse the payment if debtor consent to payment. The creditor can refuse the payment who is not interested in the fulfillment. Ayan, nagpauna siya ng 100 pesos. Ngayon, nagbayad si X ng 1 million to C. Tapos, tinanggap ni C. Do you think tama ba na tinanggap ni C yung 1 million? Siyempre hindi, dahil nagbayad na siya ng 100,000. Dapat 900,000 na lang yung tinanggap niya. Dapat in-inform niya si X na 900 na lang yung babayaran ni D sa kanya. So, ayun, tinanggap niya yung 100,000. Siya yung nag-benefit ng 100,000. Tapos, ito namang si D, sisingilin siya ngayon ni X ng 1 million. Parang nadoble yung kailangan bayaran ni D. Ayun, so ang sinasabi dito dapat magkaroon sila ng mga consent muna bago bayaran, ganyan. Tapos ganun din yung para sa interested, kapag wala nang pambayad si D kay C, pwede nga na i-pledge yung car. Serve as asan na? Wait lang. Pwede nga nang i-pledge yung car for closure. Ayan, next. Who to pay? Ayan, parehas lang din. The creditor. Kung saan ka magbabayad? Parehas lang din sa creditor, authorized agent, and successor in the interest. Ito naman sa may incapacitated. Ito yung mga kunwari, for example, kasi may mga chance na nung nagkaroon sila ng obligation, na constitute nila yung obligation, matitino pa sila. Pero nagkaroon sila ng problema sa pag-iisip. Nung time na yun, gusto mo na magbayad sa kanila. Maaari mo bang bayaran kapag wala na sa katinuan na pag-iisip? Siyempre hindi. Kaya yun, magiging invalid yun. Di mare-recognize yung obligation mo. Pero, ayan, magiging invalid yun. Pero naman, if nag-benefit naman siya dun sa binayad mo, parang pinambili niya ng mga makakain niya, ng gamit niya. Kunwari, binigyan mo siya ng phone, yung pinabayad mo sa kanya phone, tapos tinago niya lang naman to, magiging valid yun. Pag tinapon niya, hindi pa rin ma-extinguish yung obligation mo. Dito naman sa third person, maaring hindi ma-acknowledge yung binayad mo kung binigay mo lang sa third person, sa kapitbahay, ganun. Pero magiging valid to kapag nakapag-provide ka ng proofs of delivered. So, ayan, meron tayo ditong benefited na need to be proven in the following cases. Number 1, after the payment, the third person acquires the creditor's rights. Kunwari, kapag sinabi ng creditor na ibigay mo na lang kay ganito dahil may utang din ako sa kanya, ayun, pwede yun. Number 2, if the creditor ratifies the payment to the third person, ito naman kunwari, sinabihan mo si creditor na ipamigay mo na lang sa kaibigan or sa co-work mo, tapos in-inform mo yung creditor, and nag-oo naman siya na kukunin niya na lang doon. At that time, na-extinguish yung obligation mo kasi na-ratify niya eh. Number 3, if the creditor's conduct, the debtor has been led to believe that the third person had authority to receive the payment, pinapamukha niya na siya na yun yung authorized agent niya, well in fact hindi pala. Kaya okay lang yun dahil pinapamukha niya naman sa'yo. Ma-extinguish pa rin yung obligation doon. Next, Article 1240, payment shall made to the person in whose favor the obligation has been constituted or his successor in the interest or any person authorized to receive it. Article 1241, payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered or insofar as the payment has been beneficial to him. Payment made a third person shall also be valid insofar as it redounded to the benefit of the creditor. Such benefit to the creditor need not be proved in the following cases. So, ayan, we have the example here. D is indebted to C for 100,000 on maturity date. C is insane, and despite being aware on the insanity, D still paid C 100,000 pesos. Ngayon, alam na ni D na hindi naman okay yung pag-iisip ni C, pero binayaran niya pa rin si C. Ngayon, dito na papasok yung mga rules natin. Ayun, dyan na sila papasok. Kapag kasi si C tinapo niya lang naman yung pera, hindi kagaya sabi ko, hindi ma-extinguish yung obligation mo nun. May bayad ka, may utang ka pa rin. Pero kapag naman ginamit niya to sa na makakapag-benefit sa kanya, binambili niya ng mga gamit, pagkain niya, ayun, extinguish mo na yung obligation mo. Next example, D is indebted to C for 10,000 on maturity date. D went to C's house to pay. C was not in the house, and D as ex-neighbor of C who was not authorized by C to accept payment to receive the 10,000 and give it to C when he gets home. Ayun, pumunta si D. May utang si D kay C na 10,000. Ngayon pumunta si D sa bahay nila para magbayad. Ngayon, wala pala si C sa bahay nila. Si D naman tinanong niya kay X, yung sa third person na yon. Pero it was not authorized by C, ha? Hindi siya in-authorize ni C. Hindi siya yung authorized person ni C. Pero tinanggap niya pa rin yon, tinanggap ni X. At ibibigay na lang daw kapag dumating si C. Ayun, kapag naman binigay ni X na yung buong bayad kay C, okay yun, na-extinguish niya yung obligation niya. Pero kapag kulang yung binigay ni X kay C, hindi na kasalanan ni X yun. Parang mag-burden dito si D. Kasi hindi naman authorized person ni C si X eh. Kaya dapat mas mainam na kay C na lang ibigay ni D yung bayad niya. Article 1244, the debtor of a thing cannot compel the creditor to receive a different one, although the latter may be used of the same values as or more valuable than which is due. In obligation to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obliger's will. Article 1246, when the obligation consists in the delivery of an indeterminate or generic thing whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality, neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall taken into consideration. I-discuss po natin to sa next slides ha. Basahin lang po natin. Article 1249, the payment of debts in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then the currency which is legal tender in the Philippines. The delivery of promissory notes payable to order or bills of exchange or the mercantile documents shall produce the effect of payment only when they have been cashed, or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be held in abeyance. So, ayan na po, explain na po natin sila lahat yung mga binasa natin related articles sa what is to be paid. Ito, to give a specific thing, debtor cannot compel the creditor to receive a thing. Ito po yung kunwari, may isang bag. Kunwari, yung isang bag na Louis Vuitton, ang specific thing na kailangan mong ibigay, ay yun dapat ang ibigay mo. Kapag naman hindi ganon, hindi magiging valid yung payment mo. Kailangan yung specific thing yung pambabayad mo. Next, to give a generic thing. Example, ballpen ang ibibigay mo na gagamit, ballpen ang ibibigay mo for the office kasi around 50 pesos na ballpen dapat. Si creditor, hindi siya pwedeng mag-demand na tataas sa 50 pesos. For example, 500 ang gusto niya, hindi pwedeng ganon. Or, mas mababa pa sa 50 pesos yung mga panda, nagre-range siya 8 to 9 pesos. Ganon, hindi rin siya pwedeng ganon. Mas mainam na na-specify nila kung ano yung quality para hindi sila magkalituhan. Next, obligation to do or not to do. For example, may obligation ka na to repair laptop. So, yung obligation mo hindi mo pwedeng palitan. Hindi nila pwedeng sabihin cellphone na lang yung i-repair mo. Hindi. Tapos, kunwari magpapatayo ka ng apartment, then may mga pumipigil sa'yo. Ayun, di ba? Yun yung forbearance na sinasabi. Yung nililimitahan ka. Next, obligation to give a money. Kunwari, ang gusto dollars or cheque. Yun yung pambayad mo. Hindi pwedeng mag-iba ka. Yan. Next, Article 1233, a debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Article 1234, if the obligation has been substantially performed in the good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. Article 1235, when the obligee accept the performance knowing its incompleteness of irregularity and without expressing any protest or objection, the obligation is deemed fully complied with. And next is the how to pay.
How to pay. General rule. Payment must be compelled. Article 1233. The creditor or the debtor cannot be compelled to accept or make partial payment. Article 1248. Substantial performance in good faith. Article 1224. Exception. Creditor waives complete performance. Article 1235. Contrary stipulation and partly liquidated creditor. Article 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestation in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. Balik po tayo ulit sa general rule. Payment must be complete, hindi po pwedeng partial. Kailan ba allowed ang partial payment? When there is stipulation to that effect. Article 1248 provides other exception pag ang debt is in part liquidated and in part unliquidated. Example, may utang kang 500,000 due today, hindi mo pwedeng i-compel na 250,000 muna ang ibayad mo. Ganon din sa nagpautang, hindi rin pwedeng i-compel na 250,000 muna ang ibayad, wag munang i-fully paid. Unless may agreement sa contrary na pwede sa kanila ang partial payment. Article 1239. An obligation to give payment made by one who does not have the predisposal of the thing due to the capacity of alienate it shall not be valid, without prejudice to the provision of Article 1247 under the title on natural obligations. Predisposal of the thing. Ibig sabihin, the thing that could be delivered must not be the subject of to any claim. Tapos, when you say capacity to alienate, the person is not incapacitated to enter into contracts. Ang ibig sabihin sa provision na ito, ang bayad ng incapacitated na tao is not valid kasi nga wala siyang kakayahan and the creditor cannot be compelled to accept it. Example, Cain is bound to deliver a cell phone to Ezra. On due date, Cain delivered the cell phone he snatched from his classmate. In this case, Ezra cannot be compelled to accept the cell phone delivered by Cain as the latter has snatched it from somebody else and therefore does not have predisposal of the thing delivered. Article 1242. Payment made in good faith to any person in possession of the credit shall release the debtor. Ang pagbabayad ng may utang na ginawa ng walang daya sa taong may hawak ng utang ay nagpapalaya sa nangutang sa kanyang obligasyon. Example, Jonas is indebted to Ruth for 100,000. Because of this, Jonas issued a promissory note payable to Ruth or bearer. One day, Ruth lost the note which was later found by Noah. On due date, Noah presented to Jonas the promissory note for payment. If Jonas is not knowledgeable that Ruth has lost the promissory note and assuming he paid Noah 100,000 in good faith, then his obligation will be extinguished. Where to pay? General rule. Stipulations of the parties. If no, obligation to give a specific thing. Wherever the thing was at the moment obligation was constituted. And any other type of obligation, domicile of the debtor. Article 125. Payments shall be made in place designated in the obligation, there being no stipulation in if the undertaking is to deliver a determinate thing, the payment shall be made wherever the thing might be at the moment the obligation was constituted. In any case, the place of payment shall be domicile of the debtor. If the debtor changes the domicile in bad faith or after has incurred delay, the additional expenses shall be borne by him. These provisions are without prejudice to venue under the rules of court. This provision means kung saan babayaran. First rule, pag mayroong stipulation kung saan ang napag-usapan, if wala namang stipulation, we have to classify it if it delivery of a specific or determinate thing. When to pay? Upon demand. When the obligation is due and demandable, but the debtor may pay before due date if period is for the benefit of the debtor. Article 1245. Dation in payment whereby property is alienated to the creditor in satisfaction of the debt in money shall be governed by the laws of sales. Dation in payment means paglipat ng isang asset para masettle lang hindi pa nababayarang utang. Kumbaga, ipambabayad mo ang asset mo, for example, ang bahay mo, ipambabayad mo para mapunan pa ang di mo pa nababayarang utang. Article 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court shall govern. Sinasabi sa provision na ito ay si debtor ang may obligasyon to pay for extrajudicial expenses, unless may stipulation na creditor ang magbabayad ng extrajudicial expenses. Ipula sa agreement kung sino ang magbabayad ng extrajudicial expenses required by the payment. Si debtor ang magbabayad. Bakit? Kasi it's provided under Article 1247 under the law. Article 1250. In case an extraordinary inflation and deflation of the currency stipulated should supervene the value of the currency at the time of the establishment of the obligation shall be the basis of payment unless there is an agreement to the contrary. Ang sobra-sobrang pagtaas o pagbaba ng pera na nasa stipulation ay mangyayari. Ang halaga ng pera sa oras na nagawa ang obligasyon ang magiging basis ng payment, unless kung iba ang agreement. Article 1253. If the debt produce interest, payment of the principal shall not be deemed to have been until the interest has been recovered. Interest must be paid first. Kapag ang utang ay nagkaroon na ng tubo, ang kabayaran ng puhunan ay dapat na hindi tanggapin hanggang ang tubo ay hindi kasama. Article 1254. When the payment cannot be applied in accordance with the preceding rules, or if application cannot be inferred from the other circumstances, the debt which is most onerous to the debtor among those due shall be deemed to have been satisfied. If debts due are of the same nature and burden, the payment shall be applied to all of them proportionately. Ang ibig sabihin, in case na walang application of payment na ginawa si debtor and creditor, then the payment shall be applied due the most onerous debt. Pero kung yung debt of the same nature and burden, to all of them proportionately. Application of payment. What is application of payment? It is the process used to apply payments to charges based on system and user-defined priorities. Application payment requisites. At least 2 debts are due, 1 debtor and 1 creditor. Application of payment can be made only on debts that are due. Payment cannot cover all the debts due. Application of payment can be made only to debt of the same kind. Example, Chris is indebted to John of the following debts and their due dates. August 20, 5,000. August 31, 7,000. August 25, give a specific ukulele. August 26, 3,000 with 2% interest. August 27, 10,000 secured by his laptop. August 30, 4,000. Assuming Chris is ready to pay only up to 15,000 on August 29. The payment can only be applied to debts of the same kind which are already due or to debts which are most onerous proportionately. The payment can be applied proportionately to all debts except 4,000, which will only be due on August 30. Article 1255. The debtor may cede or assign his property to his creditors in payment of his debts. This cession, unless there is stipulation to the contrary, shall only release the debtor from responsibility of the net proceeds of the thing assigned. The agreements which, on the effect of the cession, are made between the debtor and his creditor shall be governed by special laws. Cession of payment or assignment. Cession or assignment in favor of creditors is another special form of payment. Again, this is a process kung saan lahat ng property ni debtor ay itatransfer sa mga creditors. Parang mga creditors ay self-sent ibebenta yung kita sa pamamagitan ng pagbebenta ng property ni debtors, yun ang ibabayad sa utang. What is the difference between payment by cession and dation in payment? Payment by cession. Debtor must be insolvent, 2 or more creditors, affects all priorities of debtor except those exempted by law, right to sell passes to the creditors, obligation is extinguished up to the extent of the proceeds from the property. Dation in payment. Debtor may or may not be insolvent, plurality of creditors is not required, affects only a specific property, ownership passes to the creditor, Obligation is fully extinguished regardless of the existence of deficiency in proceeds from the property. Furthermore, the creditor is not required to sell the property. What is tender of payment and consignation? Tender of payment, act of debtor showing intention of complying with this obligation. In this section, tender of payment is valid if you are tendering a legal tender. What is legal tender? These are bills and coins issued by Bangko Sentral ng Pilipinas. Tender of payment. So, if it's a monetary obligation, yun yung pag-o-offer na ibigay yung pera o bayad. If it's an obligation to give something, maging sa object mismo. Tender of act is offering. It is a preparatory act for consignation. Consignation, made by depositing the things due at the disposal of judicial authority, before whom the tender of payment shall be proved, in a proper case, and the announcement of the consignation in other cases. Article 1258. So, after mo mag-tender ng payment, the creditor cannot accept or refuses to accept payment. Then what should you do? Ikaw yung debtor, nagbayad ka na para matapos ang obligation mo, pero ayaw tanggapin. You have an option to consign it with the proper authority. I-deposit mo doon sa court ang pera or bagay para ma-extinguish ang application mo. Of course, this is done after complying with the formalities required by law. You have to file a case for that matter. General rule, there can be no consignation without a valid tender of payment. Exceptions, Article 1256. When the creditor is absent or unknown or does not appear at the place of payment, when he is not incapacitated to receive the payment at the time if it is due, when, without just cause, he refuses to give a receipt, when two or more persons claim the same right to collect, when the title of the obligation has been lost. Requisites: debt is already due. Tender of payment made by creditor refuses to accept payment without valid cause. Notice of consignation to interested person is given. Actual consignation of the sum due. Notice to interested person that consignation was made must be given. Article 1259. The expenses of consignation, when properly made, shall be charged against the creditor. So, creditors bears expenses of consignation. Consignation is made necessary because of the fault or unjust refusal of the creditor to accept payment. That being the case, it is purchased, the expenses should be charged against the creditor. This is also the reason why we have previous notice of consignation, kasi nga baka magbago pa ang isip ng creditor, baka tanggapin niya na ang pera. Because consignation, once it is deposited in the court, the creditor will bear the expenses. So the consignation is not properly made, or if the latter withdraws payment, obviously expenses are chargeable to the debtor. Article 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation. Before the creditor has accepted the consignation, or before the judicial declaration that the consignation has been properly made, the debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. Dito sa article na to, sinasagot natin ang tanong na, what is the effect once the consignation has been duly made? The debtor may ask the judge the cancellation of the obligation after due hearing and a judgment that all the requisites of consignation have been met, and this operates as a valid payment. Yung running of interest din is suspended, so pwede na rin i-cancel ang obligation niya. The debtor may withdraw the thing or something signed as a matter of right before the creditor has accepted the consignation, or before there is a judicial declaration that the consignation has been properly made. After all, right niya yun. Kasi di pa naman binibigay ng creditor yon. Di pa tinatanggap ng creditor at wala pa rin namang judgment ang court. In such case, the obligation will continue and all expenses are paid by the debtor. Kasi winidraw naman niya ang kanyang payment deposited to court. So walang valid extinguishment of obligation. Article 1261. If the consignation having been made, the creditor should authorize the debtor to withdraw the same. He shall lose every preference which he may not be over the thing. The co-debtors, guarantors, and sureties shall be released. So, pwedeng i-withdraw ang pera if there is an degree that the consignation is proper but there must be authority from the creditor. Now, if the creditor authorized yung withdrawal of payment, pwede na i-withdraw ng debtor, but the creditor will lose all his preferences over the thing or the money deposited to the court. Also, co-debtor, guarantors, and surety will release from the obligations.
Good day everyone, this is my report about loss of the thing. Article 1262. An obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed, without the fault of the debtor and before he has incurred in delay. When by law or stipulations the obligor is liable even for fortuitous events, the loss of the thing does not extinguish the obligation and shall be responsible for damages. The same rule that applies when the nature of obligation requires the assumption of risk. The happening of a fortuitous event in itself does not necessarily extinguish an obligation to deliver a determinate thing. Should be extinguished when the said thing should be lost or destroyed without the fault of the obligor and before he is in default. Article 1263. In an obligation to deliver generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. It is based on the principle that the generic thing never perish. The debtor can still be compelled to deliver a thing of the same kind. The creditor, however, cannot demand a thing of superior quality, and neither can the debtor deliver a thing of inferior quality. Article 1264. The court shall determine whether, under the circumstances, the force or loss of the objective of the obligation is so important as to extinguish the obligation. Example: Ezra obligated himself to deliver to Job a specific laptop. The laptop accidentally fell to the floor, resulting to destruction of its screen. If the fourth loss is so important that the obligation would have been established without it, the court may decree the extinguishments of the obligation. Article 1265. Whenever the thing is lost in the possession of the debtor, it shall be presumed that loss was due to his fault, unless there is a proof to the contrary, and without prejudice to the provisions of Art. 1165. This presumption does not apply in case of earthquake, flood, storm, or another calamity. The article establishes a disputable presumption of fault whenever the thing to be delivered is lost in the possession of the debtor. This presumption is reasonable because the debtor who has the custody and care of the thing can easily explain the circumstances of the loss. The creditor has no duty to show that the debtor was at fault. Under the third paragraph of Article 1165, the obligor who is not fault is still liable in case he is guilty of delay or has promised to deliver the same thing to two or more persons who do not have the same interest. In case of natural calamities, the presumption of fault does not apply. Lack of fault on the part of debtor is more likely, so it is unjust to presume negligence on his part. Article 1266. The debtor in obligation to the shall be released when the prestation becomes legally or physically impossible without the fault of the obligor. This clause addresses the legal and physical impossibilities Legal impossibility results when the act that must be performed is later made illegal by the law. Article 1267. When the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. Example, Miko agreed to become the school service driver of St. Bethlehem preschool for the school year 2020-2021. However, due to COVID-19 pandemic, DepEd declared that there will be no longer face-to-face class for the said school year. The students will no longer need a school service. In this case, the obligation will be extinguished. The usual norm is that the obligor is released when performance is impossible. This is also known as the frustration of enterprise or the frustration of the commercial purpose philosophy. Article 1268. When the death of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss, unless the thing having been offered by him to the person who showed it, the latter refused without justification. Example, civil obligation. Ezra is obligated to deliver a specific laptop to Luke. Criminal obligation. Ezra is obligated to retain a specific laptop he snatched from Luke. Only obligations to deliver specific, definite items that result from a crime the debtor committed are covered by the provision of this article. The debtor is responsible The debtor is responsible for recovering the item's worth if it's lost for whatever reason. Article 1269. The obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third persons by reasons of the loss. Example, Ezra is obligated to deliver a specific laptop to Luke. Before the delivery, the laptop was lost due to the fault of a third person. Even though the loss of a thing without debtor's fault ends the obligation, any resource the debtor may have against the third person as a result of the loss is transferred to the creditor in order to protect the latter's interest. Condonation or remission of the debt. Article 1270. Condonation or remission is essentially gratuitous and requires the acceptance by the obligor. It may be made expressly or impliedly. One and the other kinds shall be subject to the results which govern in officious donations. Expressed condonation shall furthermore comply with the forms of donation. Ang condonation ay isang pagpapatawad ng nagpautang sa umutang. Ito ay tinataguring isang pabuya sa isang tao at kinakailangan naman ng pagtanggap ng dapat na siyang magbayad. Ito ay pwede ipakita sa pamamagitan ng pahiwatig o pahayag. Article 1271. Article 1271. The delivery of a private document evidencing a credit made voluntarily by the creditor to the debtor implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver it should be claimed to be inofficious, the debtor hers may uphold it by providing that the delivery of the document was made in virtue of payment of the debt. When a creditor willingly gives a debtor a confidential document attesting to a credit, it is assumed that the former has given up any claim against the latter. Article 1272. Whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily unless the contrary is proved. Remission is an act of generosity in which of the obligee waives the right to enforce the duty, either completely or in the portion or aspect to which the remission relates without obtaining payment or another equivalent. Article 1273, the renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. The accessory obligation extinguish once the principal debt is remitted because the existence of the accessory obligation is dependent upon the existence of the principal obligation. On the other hand, if the accessory obligation alone is extinguished, the principal obligation remains because the existence of the principal obligation is not dependent upon the accessory obligation.
Article 1274. It is presumed that the accessory obligation of pledge has been remitted when the thing pledged, after its delivery to the creditor, is found into the possession of the debtor or of a third person who owns the thing. If the pledge was found in the possession of debtor o yung mismong may-ari ng kung anong mang accessory obligation ang ginamit, the presumption is that the pledge has been remitted. However, this presumption can be rebutted by the creditor if he proves that the thing is stolen or returned for repair. In that case, there will show no remission or walang kapatawaran. Halimbawa, nangutang ako kay Mr. Reyes ng 5,000 pesos at bilang accessory obligation, ibibigay ko muna sa kanya pansamantala ang aking kwintas habang hindi pa ako nakakabayad. Ngayon, makatapos ang isang buwan at kaya ko nang ibigay ang aking pagkakautang na 5,000 piso, ay may karapatan na din ako at kailangan na din niyang isole ang kwintas na ibinigay ko sa kanya bilang accessory obligation. Next is the confusion or merger of rights. It contains the Article 1275, 1276, and 1277. Let's first tackle about the Article 1275. The obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. This means that the obligation is void the time the debtor and lender become one with the one person. Article 1275 speaks of confusion or merger of rights. So ano ba muna ang confusion or merger? Ang confusion ay ang kapag nagmi-meet na yung qualities ng isang debtor and creditor sa isang tao lamang. The law treats the confusion or merger as a mode of extinguishment of obligation because it would be absurd since a person cannot claim payment from himself kasi naging debtor na nga siya and naging creditor pa siya at the same time. So let's now for the example. Mark is indebted to Matthew for 10,000. Mark issue a promissory note to Matthew promising to pay the bearer for 10,000. Matthew then used the promissory note to pay his debt of 10,000 to Luke. Luke, on the other hand, is also indebted to John for 10,000 also, wherein he used the promissory note he received from Matthew. John is also indebted to Mark for 10,000 and he used the promissory note as payment for Mark. So, the legal opinion here is si Mark ay naging debtor na siya and also a creditor, kaya that debt will be extinguished. So now let's go up in the Article 1276. Article 1276 states that the merger which takes place in the person of the principal debtor or creditor benefits the guarantors. Confusion which takes place in the person of any of the latter does not extinguish the obligation. This means that the obligation is extinguished if the merger or confusion takes place in the person of the principal debtor or creditor. However, if the confusion takes place in the person of any of the guarantors, there is no extinguishment of the principal obligation. So, this article talks about the effect of merger on guarantors. The accessory follows the principal, meaning if nagkaroon ng merger sa principal obligation, yung accessory obligation is also extinguished. So, for example, Mark makes a promissory note payable to Matthew. This note is secured by a contract of guarantee by Luke. Matthew sells the note to John. So, the legal opinion here is ang obligation ni Mark ay hindi pa extinguished, while si Luke ay ang magiging new creditor of Mark and the contract of guarantee is extinguished. Ibig sabihin, si guarantor is free na sa any liabilities. So, to summarize the Article 1276, if there is guarantor and the merger is in the principal debtor, the obligation is released kasi nga the accessory follows the principal. And if there is a guarantor and the merger is not on the principal debtor but only on the guarantor, the principal obligation is not extinguished pero ang accessory obligation is extinguished. Article 1277. It states that confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concur. So, ito ay dahil sa merger in joint obligation, debts are distinct and separate from each other, and the joint debtors are liable on that debt being considered equally. Therefore, if the confusion takes place in one of the joint letters, the principal obligation is extinguished up to the share which corresponds to him. So, let's have an example. Matthew, Mark, and Luke are jointly liable to John in the amount of 9,000 pesos, evidenced by a negotiable promissory note. John endorsed the note to Paul, who in turn endorsed to Matthew. So, in that case, ang share ni Matthew in the obligation is extinguished kasi there's a confusion na to in himself kasi naging creditor na siya, naging debtor siya and naging creditor na siya at the same time. Samantala, ang utang naman ni Mark and Luke na tig 3,000 na lang ay mananatili. Kasi wala naman nangyaring confusion sa kanilang dalawa. So ngayon, si Mark and Luke na lang ang may utang kay Matthew na nagkakahalaga ng 3,000 pesos. Now, let's move on to the compensation. In Article 1278, compensation shall take place when two persons in their own right are creditors and debtors of each other. So, ano nga ba ang compensation? Compensation is the extinguishment to the concurrent amount of debts of two or more persons who are in their own right will show the creditor and debtor of each other. So, in other words, compensation is si debtor ay meron ng debt of favor to the creditor. And for some reason, si creditor naman ay meron ding debt in favor sa debtor niya. Pero para hindi tayo malito, ano ba ang kaibahan ni compensation kay confusion or merger? Si confusion or merger, meron lamang involved na one person and only one obligation. Samantalang si compensation naman, there's a two person na involved na naging debtor na siya and naging creditor na sila sa isa't isa. Ngayon, ano naman ang kaibahan ni payment sa compensation? Si compensation is operated by law, habang si payment is act by the parties. Isa pa, si payment kailangan kumpleto, while si compensation the law permits partial extinguishment of the obligation. Now, there are four kinds of compensation. Those are legal compensation, conventional compensation, facultative compensation, and judicial compensation. At those are i-discuss natin pamaya-maya. Pero unahin muna natin si legal compensation. Ano ba si legal compensation? Legal compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, even though the creditor and debtors are not aware of the compensation, based on the Article 1290. So, the rule on legal compensation is stated in Article 1290 of the Civil Code na nagsasabi na kapag lahat ng requisites ay na-mention o present kay Article 1279, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, kahit na ang creditors and debtors are not aware sa compensation. Ano nga ba ang nilalaman ng Article 1279? In order that compensation may be proper, it is necessary that each one of the obligors be bound principally and that he beat the time of principal creditor of the other. Second, that both debts consist in the sum of money, or if the things due are consumable, they be of the same kind and also of the same quality in the latter has been stated. Third, that the two debts be due. Fourth, that they be liquidated and demandable. And fifth and the last, that over neither of them there be any retention or controversy commenced by third person and communicated in due time to the debtor. Now, let's state an example for Article 1279. Joel is indebted to Miriam for 10,000 pesos due on August 27, 2020. Miriam is also indebted to Joel for 10,000 pesos due on August 30, 2020. If Joel and Miriam did not pay their debts, what will happen to the obligation? So, the legal opinion here is there can be a legal compensation on or pagkatapos ng August 30, 2020, kung saan ang kanilang parehas na utang is already inadue na. Now, let us move on to Article 1280 that states that notwithstanding the provision of the preceding article, the guarantor may set up compensation as regards what the creditor may owe the principal debtor. It says that the compensation benefits the guarantor, although the guarantor is only subsidiary. He is not principally bound that he is given the right to set up compensation. So, si guarantor ay may karapatan to set up the compensation if ever. So, let's state an example. Mika owes Amos 10,000 pesos wherein Isaiah is her guarantor. Assuming Amos is indebted to Mika for 9,000 pesos, is there legal compensation between Isaiah and Amos? The legal opinion here is kapag si Mika ay nakapagbayad kay Amos, then si Amos ay may karapatan to go against Isaiah up to the extent of the remaining balance of Mika's debt na nagkakahalaga ng 1,000 pesos na lang. For the second type of compensation, conventional compensation. Compensation based on the consent of both parties. Article 1282, the parties may agree upon the compensation of debts which are not yet due. This is now the conventional, or we can also call it voluntary compensation. It is an exemption to the general rule that only debts which are due and demandable can be compensated. Ngayon, yung mga requisites na nakapaloob sa Article 1279 kanina, hindi siya ngayon maa-apply dito sa conventional compensation because this kind of compensation has no special requisites. Next is the judicial compensation. It is the compensation to be divided in court. It is also Article 1283 that states that if one of the parties to a suit over an obligation has a claim for damages against the other, the former may set it up by proving his right to set damages and the amount thereof. Sinasabi dito na sa party may set of na party may set up his claim for damages against his obligation to the other party by proving his right to set up the damages and the amount. And additionally, sa judicial compensation, all the requisites under the Article 1279 must be present, pero ang exemption lamang ay ang time of pleading. The claim is not yet liquidated. To summarize the judicial compensation, it is through the court and it is declared by a final judgment with the court proceedings. Now, let's move on the last type of compensation, the facultative compensation. It is when the only one of the parties may claim for compensation. So, isa-isahin natin ang mga nakapaloob sa facultative compensation. Una na dito ay ang one of the debts arises from the depositum or from the obligation of a depository or of a bailee in comodatum. It is from Article 1287, Paragraph 1. Let's analyze the example. Joseph is obliged to give Abraham a ukulele. Joseph left a ukulele at Abraham's house. That is deposit. What is deposit ba or depositum? Depositum is when the thing is given by one person to another to keep it until it is not yet demanded back. Next, Joseph is obliged to give Abraham a cell phone. Joseph lent Abraham a cell phone. That is comodatum. What is comodatum? It is a contract that it is included by the delivery ng isang bagay that is lent by the lender to the borrower. So, punta tayo sa pangalawa. The second is up against a creditor who has a claim for support due by gratuitous title. It is from Article 1287, Paragraph 2. Let's analyze the example. Maria and Joseph were married for 10 years with one child. Unfortunately, they got divorced last year and the court ordered Joseph to give 20,000 pesos as monthly support to Maria and their child. Maria is indebted to Joseph for 20,000. Assume both debts are due. So, the legal opinion here is the facultative compensation ay magkakaroon lamang ng bisa kung si Maria will be the one to claim compensation and not the otherwise. Next is the third classification of facultative compensation. One of the debts consists in civil liability arising from a penal offense, and it is from Article 1288. Let's analyze the example again. Cain was indebted to Abel for 50,000 pesos. Abel attempted to kill Cain. Because of the traumatic experience of Cain, the court awarded him 50,000 pesos damages. Abel was also criminally liable. So, the legal opinion here is the facultative compensation can only be compelled or obliged by Cain. at hindi kay Abel.
Article 1284. When one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. So, ang ibig sabihin nito, kapag ang isa o parehong mga utang ay maaari kansela o pawalang bisa, maaari nilang bayaran ang bawat isa bago pa man ito ay pawalang bisa o kanselahin ng hukuman. So, for example, Jeremiah owes Isaiah 50,000 pesos. However, Jeremiah, through fraud, was able to make Isaiah sign a promissory note that Isaiah is indebted to Jeremiah for the same amount. So, ang nangyari dito, dati may obligation na si Jeremiah kay Isaiah na 50,000. Tapos, nagkaroon din ng obligation si Isaiah kay Jeremiah sa halagang 50,000 din. Pero, sa paraang panloloko. Ang utang ni Jeremiah kay Isaiah is valid. Pero ang utang ni Isaiah kay Jeremiah is voidable. So kahit pala ang utang or contract is voidable, base dito sa ibig sabihin ng Article 1284, when one or both debts are rescissible or voidable, they may be compensated. Magkakaroon pa rin ng compensation sa issue na ganito. And maaari lang ipawalang bisa o kanselahin ng mga ang void na contract ni Isaiah kay Jeremiah kung ang hukuman ay ikakanselahin ito o ipapawalang bisa. Article 1285. The debtor who has consented to the assignment of rights made by the creditor in favor of a third person cannot set up against the assignee the compensation which would pertain to him against the assignor was notified by the debtor. At the same time, he gave his consent that he reserved his right to the compensation. If the creditor communicated the cession to him but the debtor did not consent thereto, the latter may set up the compensation at debts previous to the cession but not of subsequent ones. If the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also later ones until he had knowledge of the assignment. So, ito ang compensation habang ina-assign ang debts. Itatakal natin yan kapag tapos na tayong makapag-discuss ng example. So, ito ang example. James is indebted to Peter for 100,000. Peter, on the other hand, is indebted to James for the following amount with their corresponding due dates. September 13, 10,000. September 18, 12,000. September 12, 8,000. September 25, 10,000. And October 1, 15,000. So, si James daw is may utang kay Peter for 100,000. On the other hand, si Peter ay may utang din naman kay James ng ganito mga halaga. 10, 12, 8, 10, 15. Pero kung titingnan nyo is parang marami. Pero kung pagsusumasamahin lahat yan, halagang 55,000 lang yan. So, sa halagang 55,000, hindi pa rin niya mako-cover up ang utang ni James kay Peter na 100,000. So, may utang nga si Peter kay James na na 55,000. Si James naman may utang naman kay Peter 100,000. So, assuming on September 24, Peter assigned the 100,000 to John, James gained knowledge of assignment on September 26. How much can John collect from James? So, dito na pumapasok ang ating compensation in assigned debts. So, for the first column, how assigned, with debtor's consent with reservation to compensation. Tapos, ang extent of compensation can set up compensation as to any debts due. And ang how much can James set up as compensation, 55,000 pesos. John can collect 45,000 pesos. So, ganito ang nangyari. Kung inassign na ni Peter yung 100K kay John, kapag sinabing assignment kasi, yun na yung binibigay na right to compensate kay John. Ibig sabihin, ang bagong creditor na is si John. Ang nangyari is, may knowledge na si James na inassign na kay John ang compensation. Pero at ang right to compensate. Pero at the same time, ni-reserve niya yung right niya as to compensation. Yung utang niya, kumbaga, yung utang sa kanya ni Peter, ni-reserve niya. So, ang mangyari, pwede niyang i-set up or i-compensate ang mga magjuju na. For example, si John ay mangongolekta ng October 15. So, para makover na lahat ng debts, ang pwede niyang masingil ay 45,000. Bakit? Kasi ang October 15, so, ang kokolektahin ni John is, si John ay mangongolekta ng October 15. So, mga due na makakover lahat is September 13, 18, 22, 25, and 1. Ang pwede masingil ni John dahil nga si James ay nag-set up ng compensation, 45,000 ang pwede niyang masingil kay James. Habang si Peter, dahil may utang siya kay James na 55,000, ang babayaran na lang ni James is 45,000. Dahil nakapag-reserve siya ng compensation, ng right to compensation. Okay, next column. With debtor's consent, however, without reservation to compensation. So, may consent daw ni debtor, pero wala naman siyang reservation to compensation. So, ang extent of compensation is cannot set up compensation to any due dates. To any debts due. So, kapag pala si James ay hindi nakapag-reserve ng compensation, ng right to compensation, ang pwedeng makolekta ni John kay James is 100,000. Yung buong utang ni James is babayaran niya kay Peter ng 100,000 buo. So, ang utang ni Peter is hindi pa mababawas doon. Kasi nga, hindi na nakapag-reserve ng right to compensation si James. So, buong 100,000 ang babayaran ang pwede makolekta ni John kay James. Okay, Article 1286. Compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. Okay, for example, Jacob obligated himself to deliver to Isaac 1,000 bags of cement in Jensan. Isaac is also bound to deliver to Jacob 1,000 bags of cement of the same kind in Isabela. So, si Jacob daw is magdi-deliver kay Isaac ng 1,000 bags of cement na manggagaling sa Jensan. And si Isaac naman ay magdi-deliver din kay Jacob na 1,000 bags din ng cement na manggagaling sa Isabela. So, as you can see, wala silang nilabag dito na na legal compensation. Kasi same ng i-deliver, same din ng Kaso, ang pinaka-problem lang dito is the transportation cost of cement to Jensan is 5,000. So, and papuntang Isabela naman is 2,000. So, ang nangyari dito is pareho sila na i-deliver, kaso ang transportation naman is magkaiba. So, lugi yung magbabayad ng transportation sa halagang 5,000. So, para ma-purify ang issue na ito is if Jacob claims compensation, he must indemnify Isaac amount of 3,000 for the expenses of transportation of the rice to Jensen. So, magbabayad si Isaac kay Jacob ng danyo sa halagang 3,000 para nga naman kasi fair yung transportation nila. Okay, so let's move on to novation. So, meron tayong iba't ibang kinds of novation based on Article 1291. So, number 1 is real novation or the change of prestation or the principal conditions affecting the obligations natin. So, pangalawa is personal novation. So, wherein we replace the subject that involved in the obligation. It's either the debtor or the creditor. So, kapag change in debtor, you called it substitution. And kapag naman change of creditor, that is called subrogation. Okay? So, innovation, nagkakaroon ng some changes such as change of prestation or the real novation. And the other one is change of the subject, which is creditor and debtor or the personal novation. So, specifically, substitution and subrogation. Ngayon, punta tayo sa effect of innovation. Old obligation, general rule. Old obligation is extinguished and replaced by the new one stipulated. Article 1292. So, meron dito, if original obligation, itong nasa baba, if original obligation is void, novation is void if the original obligation was void. So, kapag ang original obligation to is void, void din ang novation. If the original obligation is voidable, effective if contract is ratified before novation or annulment can only be claimed by the debtor. Article 1298. So, ang sabi dito, kung ang original obligation is voidable, ito ay valid. So, makikita nyo dito sa may nito, ang void and voidable contracts is magkaiba yan. Tapos, sunod tayo. If new obligation is void, kung ang bagong obligation daw is void, the original shall subsist unless the parties intended that the former relation should be extinguished in any event. Article 1297. So, sabi dito, if the new obligation is void, void din ng novation. So, in a summary, ang original obligation, kapag yan ay void, void din ang novation. Pero kapag voidable naman ang original obligation, it is valid. Tapos, ang new obligation naman is, kapag yan ay void, void din ng novation. Effect of novation on accessory obligation. So, what if may nakatouch na accessory obligation? When the principal obligation is extinguished, na-extinguish down principal obligation, in consequence of a novation, accessory obligations may subsist only insofar as they may benefit third persons who did not give their consent. So, for example, Caleb owes Joshua 5,000 with interest at 10%. May utang to si Caleb kay Joshua na 5,000 with the interest of 10%. Ano ba ang 10% ng 5,000? Diba 500? Ngayon, Joshua owes Moises. Third person naman natin si Moises. Si Joshua, may utang naman daw siya kay Moises ng 500. It was agreed among the parties that Caleb would pay the interest of 500 to Moises. Napagkasundoan ng parties na babayaran daw ni Caleb ang interest niyang 500 kay Joshua para mabayaran ni Joshua si Moises ng 500. Siya na lang daw magbabayad ng interest kay Moises. Kumbaga, yung utang ni Jacob ni Joshua kay Moises na 500. Since si Caleb may interest siya ng 10%, siya na lang daw magbabayad nun kay Moises. Later on, Caleb and Joshua executed another contract. Nagsagawa daw ng bagong kontrata si Caleb at Joshua, whereby they agreed that Caleb would deliver Joshua a laptop in payment of the loan. So, nagbagong isip din ni Caleb. Hindi na daw siya nag-extinguish sila ng bagong kontrata na si Caleb is magbibigay na lang daw ng laptop kay Joshua para pambayad ng utang. Ngayon, tandaan natin, hindi nag-earn ng interest ang laptop. Matik na yun kapag nagbigay si Caleb ng laptop kay Joshua, zero na ang utang niya kay Joshua. Ngayon, ang tanong, meron pa bang utang si Joshua kay Moises na 500? Ngayong ang dating na pagkasandaan nila is magbabayad daw ng 500 si Caleb kay Moises dahil ito ang interest. Meron pa ba siyang utang? Ang answer is yes. Bakit? Dahil kapag hindi nag-consent si Moises, magkakaroon pa rin dito ng liability si Joshua kay Moises. Pero kapag naman si Moises ay nag-consent, okay, pwedeng hindi na magbayad si Joshua kay Moises ng 500. Kasi, payag na siya sa novation na gusto mangyari ni Caleb. Yung pagbabago ng obligation. Ganun lang. Okay, so substitution. Dito muna tayo substitution. Article 9 based on novation which consists in substituting a new debtor in the place of the original one may be made even without the knowledge or against the will of the latter, but not without the consent of the creditor. Payment by the new debtor gives him the rights mentioned in Articles 1236 and 1237. So, ngayon, ang ibig sabihin daw ng substitution is yung pagpapalit ng debtor. Okay? So, it doesn't matter kung mag-consent si new debtor sa old debtor dahil ang lagi nating isipin, ang kailangan lang natin dito is ang consent ni creditor. Okay, kahit anong sabihin pa ng new debtor, kahit against the will ni new debtor yan, basta sinabi ni creditor na magbabago ng debtor, walang magagawa si new debtor, kundi siya ang papalit sa old debtor. Ganun siya sa substitution. Ngayon sa delegation, substitution, delegation, yun naman ay if ever ang scenario naman dito is si old debtor ang nag-insist or nag-initiate na magpe-present siya ng bago niyang debtor kay creditor. So siya na yung nagpresenta na eto po sabi niya, eto po may bago na po akong debtor. Ipe-present ko po sa inyo, siya na po ang magbabayad ng aking utang. So ganun ang substitution delegation. So dito sa next page natin, papaano ba mai-revive ang old debtors debt? Okay? Paano maibabalik kay old debtor ang kanyang utang? Okay? So, meron tayong dalawang step. Dalawang step kasi kapag ang isa dyan is hindi naman totoong nangyari or hindi naman hindi naman naganap, pwedeng kay new debtor talaga mapupuntang ang utang ni old debtor. Okay? So, number 1, new debtor's insolvency exists before or during delegation. Okay? So, before and during delegation pa lang is wala nang kakayahang magbayad si new debtor or ang insolvency kung tawagin. Wala na siyang kakayahang magbayad ng existing na old debtor's debt. Okay? So, ang pangalawa, the old debtor has knowledge of the insolvency, or if he has none, the new debtor's insolvency is of public knowledge. Article 1295. So, ang pangalawa, kung ang old debtor daw ay alam naman na pala na walang kakayahan si new debtor na makapagbayad, or kahit hindi niya alam, basta alam ng publiko na kunwari lahat ng taong nakapaligid kay new debtor, alam nilang lahat na walang kakayahang magbayad si new debtor ng utang ni old debtor, yun pa lang is pwede nang maibalik ang utang ni old debtor sa kanya mismo at hindi na pwedeng ipasa kay new debtor. Gayon, yun ang substitution delegation. Yun ang rule ng substitution delegation. So, dito naman tayo sa expromission. Expromission, dito naman is kapag si new debtor na, yung ang bagong debtor na ang nag-initiate sa kanya. Kumbaga siya na ang nag-present ng sarili niya kay creditor. Sabi niya, ako na po ang magbabayad ng utang ng dating may utang sa inyo. Ako na po ang mag-i-initiate. Kunin niyo na po ako. Kapag ganun ang nangyari, meron pa bang chance na maibalik kay old debtor ang kanyang utang? The answer is no. Kasi dito sa expromission, there is no, number one, there is no revival of old debtor's debt. Dahil nga, si new debtor na ang nagpresenta, siya na mismo nag-initiate. So, wala nang balikan yun kay old debtors.
Subrogation, we have different types. The first is legal subrogation. It happens when creditor pays another creditor who is preferred even without the debtor's knowledge. Di ba kapag sasabihin natin subrogation, it is a change of creditor. So we have example here. Nahum owes Paul 1 million pesos secured by mortgage on the land of Nahum. Nahum also owes Peter 200 pesos. The debt is unsecured. Under the law, Paul, who is a preferred creditor, has preference to payment with respect to the land as against Peter, who is merely an ordinary creditor. If Peter pays the debt of Nahum to Paul, Peter will be subrogated in Paul's right so that he can have the mortgage foreclosed in case Nahum fails to pay the 1 million pesos debt. Ngayon, sabi dito, si Peter, binayaran niya yung utang ni Nahum kay Paul. Kasi si Nahum may utang na 1 million pesos, and then may utang din siya kay Peter na 200 pesos. Ngayon, si Peter, binayaran niya si Paul sa utang ni Nahum na 1 million pesos. Ngayon, ang mangyayari, magkakaroon ng change of creditor kasi si Peter yung nagbayad. Kaya subrogate niya lahat ng rights na yon. And then next, kapag sinabi kasing legal subrogation, di ba? Masusubrogate nung creditor lahat ng rights nung sa previous creditor. So, automatically, Peter, subrogate is masusubrogate niya ng rights lahat kay Paul. Ngayon, ano ba yung mga rights na yun? Rights to claim, pwede niya na i-foreclose yung mortgage in the land. Ayun. Under the law kasi, when creditor face another creditor who is preferred, that is legal subrogation. Next. When third person not interested in the obligation pays with the express of tacit approval of the debtor. Example, Nahum owes Paul 10,000 pesos. Peter pays Paul with the express or implied consent of Nahum. Ngayon si Peter, binayaran niya si Paul. Legal subrogation na yun kasi may consent na. May consent na si debtor. In this case, Peter will be subrogate to whatever rights with the previous creditor have. So, ayan po nun. Ayan. So next is subrogation number 3. When even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter's share. For example, supposing the same, ayan, pares lang yung sample niya. Parang sinasabi dito sa number 3, kahit walang knowledge, kapag interested yung magbabayad ng obligation, there's still legal subrogation. Ngayon, dito si Peter is a guarantor. Ibig sabihin, interested person yan. If may rights si Paul to foreclose its certain mortgage, pwedeng makuha ni Peter kasi interested person siya. Okay, number 3. And then the next types of subrogation is conventional. Conventional subrogation of a third person requires the consent of the original parties of the third person. Ayan, these are the situations wherein hindi siya pasok dun sa legal na meron pa rin subrogation. Basta may consent yung original parties and mapag-uusapan lahat. Okay yun. And last one, partial subrogation. Under Article 1304, creditor to whom partial payment has been made may exercise his right for the remainder, and he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. So we have example here. Joseph indebted to Mary for 50,000 pesos and Martha pays Mary 40,000 pesos with the consent of Joseph. So, ayan na po, dyan lang po yun. Kasi may mga rules tayo. Dyan na po yung, para malalaman mo yung kung sa partial ba siya ganito. With consent, pasok rin siya sa legal subrogation. But then, kaya mas pasok siya sa partial subrogation kasi hindi buo yung binayad niya. 40,000 pesos lang yung binayad niya instead of 50,000 pesos. Ngayon, mas prefer dito sa partial kapag hindi na kayang bayaran ni debtor is yung original debtor na lang muna magbabayad. So, ayun lang, ganun lang po kasimple sa partial subrogation. And next. And I hope you've learned a lot in this lesson, and that would be all. Thank you.